Excellent. Can you hear me? I'm
I can
assuming.
hear you. Yes, we can.
Perfect. All right. Thank you, David. I guess first of all, thank you for putting on this webinar. My name is Jay McLean. I'm happy to be involved to represent M&P and just generally represent all SR&ED stakeholders. And so this one, this case is interesting because it's a lot around technical eligibility, and some projects were deemed eligible for SR&ED and some not deemed eligible for SR&ED. And so this dates back quite a ways, back to 2010 to 2012. There are 3 different fiscal years submitted. The judge ruled on this case in December 2019, so not all that long ago. Overall, I'll try to give a brief overview, and then we can kind of dive into a couple examples of the projects, and then talk about maybe some of the takeaways, which is probably most important. The details around this company is that they were a mobile concrete company and submitted 14 projects that ended up in this court case. The company was represented by itself, the president and founder, Jacques, and then as well as another engineer that worked at the company. And the CRA had 2 different RTAs involved. So kind of the facts that's outlined in the court case document, paragraph 30, if anybody has that or wants to kind of reference it, was that the taxpayer testified that they did in fact have the dates and times and a brief description of when the tests were conducted in a notebook. And while they weren't, say, crystal clear for perhaps maybe another engineer to review it, the taxpayer could in fact understand it themselves and work in conjunction with their computer files to kind of reconstruct what was put together, or what was documented and what happened in the project. So I think reading between the lines, I'm thinking that there's probably an opportunity to improve the kind of documentation and of all the tests conducted and whatnot there. So overall, there are a lot of different variables. Again, this has to do with concrete, and the typical kind of components of concrete are cement, sand, stone, and water, as well as some adjuvants or additives. You'll come across issues around how much entrained air you have in the concrete, the super plasticizers or different additives and latex that are added for kind of achieving different properties. And in the court document, you can see that the taxpayer had 300 different concrete mixes, and they said they develop about 15 to 20 new ones per year, and that's a combination of all these different factors. There's 6 or 7 different cements they can use, different types of stone or sand, and hundreds of different additives that could be utilized. So that's kind of the facts or the items they were varying. And so I guess naturally it comes down to kind of the question about kind of benchmarking the prior art, or what is kind of standard practice in the industry. And you can see that the taxpayer worked with the MTQ as well as the universities. And as a starting point, they did bibliographic research as well as discussions with colleagues and industry and university professors, and kind of determined that the existing documentation and the public domain, the studies and knowledge base, do not really address the issues that this taxpayer was looking at. And they were really working with mobile concrete mixers. So your typical concrete, is mixed kind of in a controlled environment in a factory, gets put in a truck that you see driving down the road that spins and keeps the concrete consistent. This was a different type of mixing, mobile concrete that's mixed on site. So that was a new variation, as well as the existing public domain documents didn't really touch on the winter factor or durability factors that they can experience in Quebec. So all of these items kind of form kind of the hypothesis around kind of the desired mixture. And I think the concern really for this project in general or this case in general is around, the evidence of an advancement and evidence of a systematic investigation. And, obviously all of these projects are going to relate to Income Tax Act 37 and Section 248(1). So if we jump into the specific projects, you can see there was 6 that I've kind of highlighted here. These are all ones that went in the taxpayer's favor, meaning the SR&ED was awarded to the taxpayer, and I thought we could dive into to talk about a couple and then maybe look at the judge's comments and maybe have a discussion or any questions on these. So this specific project, you can see, was 1104. This means it was the 4th SR&ED project submitted in the 2011 year. Was for a quick setting, self-compacting concrete. I feel like I'm a concrete expert after reading this case, which I'm not, as I have a smile on my face. But nonetheless, the facts of the case, as outlined in paragraph 261, is that this was really intended to be a concrete repair. So a customer came to this taxpayer and said, "Can you repair the floodgates, the slideways for the floodgates of a hydroelectric dam?" And the critical aspect is that the valves could not move while the concrete was poured and cured, and so that resulted in the need for a very quick drying concrete without any deformation. And the objectives set, you can see at the bottom of that slide there, really were comparing what the taxpayer had, what type of mix and concrete that they currently had, and currently they were able to achieve 10 megapascals, which is the compressive strength of the concrete, and they could do that in about 48 hours. They can get concrete to cure to that level. But in this application, they wanted the customer wanted it to cure within 24 hours. Likewise, they also wanted it to cure within 7 days to be 50 megapascals in strength. So the current technology, the current mix that they had, would cure to 50 megapascals in 28 days. So you can see a very significant improvement upon, or at least very striving for a significant improvement in their cure times. So with that in mind, the court document outlines that the projects were initially denied in paragraph 269 on the basis that the activities could not be classified as SR&ED, and it is well known that the addition of accelerator admixtures are used to obtain better resistances more quickly. And hardening more quickly. In addition, the RTA and CRA comments, I think, around that there was no systematic research carried out within the framework of this project, and the method base was trial and error and using available knowledge. So that was the original reason why this project was denied. And the experimentation high-level summary is outlined in the the court case document. And initially, the taxpayer did some visual tests, tried to evaluate the setting time of kind of the standard concrete mix that they use. They increased the accelerator, which did in fact lead to a faster setting of the concrete. However, it did not achieve those strength properties that they were looking for. So then the taxpayer worked with a cement manufacturer, and they had many different iterations of different formulation changes on the cement that forms part of the concrete mix. And then next they tested different cement and mixed it with a general purpose cement in order to try to improve that strength test that they were trying to achieve. And then finally they opted to use a binary cement, which they comment they had not used in 10 years, and they ended up replacing the typical super plasticizer with another additive, which typically was known to be less effective, and they eventually were able to increase and achieve that 24-hour target. So very high level kind of summary of the experimentation that took place. So what did the judge say? So the judge said that Mr. Bertrand made a comment that yes, we were aware that binders or additives have been the subject of publicly available studies. However, what is not documented is the combination of all these components within the context of self-compacting concrete and with the mobile concrete mixture that introduces a different mixing energy. Hence, there's the presence of a technological uncertainty when you combine all of these elements. And the ruling that the judge made is the judge made, I do not believe the taxpayer is simply qualifying products. And as practitioners, we hear that a lot. You're just evaluating or current current off-the-shelf products or technology, or mixing kind of different technologies together or whatnot. The judge went on to say, on the contrary, the taxpayer did create a quick setting self-compacting concrete that did not exist before. So there was kind of some advancement there, and the taxpayer, it was acknowledged by the judge that the taxpayer could not trust any of the current studies. And so likewise in 274, there was numerous tests that were quoted that were done by independent laboratories, and there were lab reports, and then the verbal testimony as well. So that the conclusion of the judge was, yes, in fact, this project does constitute SR&ED. So this slide really just kind of summarizes all the different key criteria, around kind of the objectives and the different, uncertain mix aspects and costs and whatnot. And this kind of comes to now our commentary section. And really, I think this seems to revolve around defining a TU and how to do so, and what is a reasonable search, or how do you define a TU? What sources do you use, or search terms, and is the prior experience of that taxpayer relevant in defining a TU? And so we thought for a second maybe we should just explore what prior art samples exist. And so this is just something that we've done. We've gone and just done a quick kind of Google patent search to see if this would be useful. And you can see at the top there that we entered in the same kind of project type description that they're working with around the influences of binders and additives in performance of self-placing concrete. And so this was one of the patents or articles that came up, and you can see we pulled a bit of a snippet from there. The overall, I mean, this study doesn't line up 100%, or this patent doesn't line up 100%, but it does look at, concrete in cold climates. It also looked at asphalt with cold climates. But it did not kind of make any commentary around, mobile mixing or achieving, 10 megapascal strength within 24 hours and whatnot. I mean, it was somewhat relevant, but not a perfect match. So likewise, then next we typed in quick setting self-compacting concrete here for the Google patent search, and a few more items, patents and applications have popped up here. And this one did talk about the freeze thaw and the heaving risk that can take place in cold climates. But again, it didn't line up 100%. But this was a fairly quick and easy search. I'm trying to think of a way to define or establish a TU, and I don't think there's any absolute rule on what is a reasonable search. Obviously, the more searches we have, the better. Maybe these documents can provide similar objectives, and maybe they're using different methods or different ideas or synergies. So anyway, that was kind of interesting to look at it through that lens. I think another couple of interesting comments the judge made is they dismissed that the trial and error argument, and that comes up again on the next case, so I'll hold a few comments for that. Also, interesting comment the judge made about the taxpayer working with a third party, in this case, the cement manufacturer. And the exact quote was, "The scientific method does not prevent teamwork." And that really stood out for me when I read this. And the judge went on to say, and that the direct planning of a trial influences the activities carried out by that taxpayer. And so I think there's probably, practitioners and stakeholders that have been in this situation where, there's third parties involved. And anyway, that was an interesting outcome and comment made by the judge. And then lastly, on this project, I think the last comment was just really around having detailed records. I mean, there was some labor hours that were removed, and I think just having more detailed records, even around kind of that defining that TU, would even strengthen this project, even though it was accepted by the judge as shred. I think there's opportunities to improve a bit there. So I'm going to run through, just highlight this case, because it also kind of, again, it's dealing with concrete, and there's a few similar items that come up and a few different items, and then maybe we can pause and I can pass it over to Elizabeth, and or we can have some questions. So switching gears now, this is kind of a separate project that was submitted in the shred claim. This was a 2012 year, the first project, and it was around using latex and developing a fast-setting concrete. And you can see that, again, this started by a customer that came to the taxpayer. A customer was Transport Canada, and essentially wanted to know if they could develop concrete to repair the taxiways at the Montreal airport. Essentially, they wanted to do this using a quick-setting concrete that would get the aircraft taxiways, operational as soon as possible. Obviously, they can't be down for weeks on end while the concrete cures. So this revolved around removing the latex component that was, added into the typical mixture. That would kind of, they're obviously trying to develop, that rapid achievement, get that strength to a certain level, and have certain durability and flex capabilities within the concrete. I feel like a concrete expert here. I said that. It's pretty funny. Okay, so let's jump right through to why the project was denied. So the project was originally denied because it was deemed that this was a commercial project and not a shred activity. Also, comments were made, as per the court document, that the majority of the steps taken and discussion with the taxpayer experts and partners show that information was accessible, I'm assuming accessible in the public domain, and that this approach is an ordinary method, and tests are trial and error based on kind of available knowledge at the time. So the difficulties encountered are also normal. That was another statement that was made, and can be resolved by current practices in the field. So that was the reason the project was denied. Again, very high level kind of experimentation, what was done. They did have, previous failed attempts, but then they ended up finding that this super plasticizer additive could improve concrete without the use of latex, and improve the concrete setting and compression strength. So this kind of led to formulations of two mixtures. Both were tested in a lab, and to evaluate their compression resistance at a young age, meaning just several hours after mixing. And that kind of led the taxpayer to study different possible adjuvants or additives that come in liquid form for the mobile concrete mixture, and they made a note that in the case that typically those additives are solid input, powder input, as opposed to liquid, and that, I guess, formed a significant factor in this case as well. And then finally, some of the tests that they did, yes, they did achieve some faster setting concretes, but they were not able to achieve the chipping resistance or the air bubble consistency and network, and so those were kind of didn't really come up to the bar that they were looking for as far as their properties. So what did the judge say in ruling on this? You can see that under 320, around the technological uncertainty, they could not predict if the objectives could be met using the current technical studies. Yes, the objective was to develop a new product for sure, and evaluate, something without latex, but would still have kind of the same properties as latex. And they were trying to kind of understand the interactions of the different additives and compatibility in this quick setting kind of environment that they were looking for. And it was also interesting to note that the documentation, the public documentation, was almost non-existent. Um, and that, I think, formed a was a factor in the outcome of this. So working down through kind of paragraph 321 and further on, you'll see that there's new knowledge gained in the performance of certain superplasticizing additives in this mixture, and they, hypothesized these additives could yield the same properties as using latex. So for all of these reasons, the judge saw this as being, yes, an eligible shred project. So what are our comments? And I'm going to just pull out a few comments that jumped out again from me from the judge here. And obviously the comment around the tax authority, saying that this was an emergency repair and it was a commercial project. And I think the issue around this is really, does the commercial value or the fact that this is within the context of a commercial project, does that remove the shred eligibility? And my opinion is likely not. Maybe in some cases, depending on the work performed, but in this case, the judge decided that it did not. And just another reference, Dave mentioned some cases prior to around the cultures Laflamme and Consultex also touch on this kind of commercial environment, if anyone is interested. But basically, the takeaway from this is that yes, shred can exist within the development of our product or service, and that science should determine the eligibility. It seemed to me that the court overall likes to see shred projects that start with due diligence searches and existing prior attempts and kind of helping to define the technological uncertainty. I think the judge actually went on to say in 327 that hours spent doing bibliographic research served to support the development of the mixture by the taxpayer and support shred activities. So interesting how the judge saw that the due diligence time in spending and doing the research was actually eligible for shred. Often as practitioners, I think we see otherwise. And another item that jumped out was the verbal testimony again was accepted and was deemed kind of a critical factor in establishing that this was a TU. And finally, my comment on trial and error. Again, it was argued that this was a trial and error project and not shred eligible. And the judge's determination here, in exact words, there were that the tests were carried out and modifications to adjust the dosages were made in reaction to these results obtained, and therefore the scientific method was followed. So I think sometimes we struggle with commentary around this as trial and error, but in this case the judge decided that that was not applicable and that the project was in fact deemed, yes, eligible for shred. So I'll pause there. I'm not sure, Dave, if you wanted to do any questions, or Elizabeth, if you wanted to jump right in and talk about some of the specific projects in this same case where they were basically ruled ineligible. I'll pass the controls over.
You'll pass the baton over to me. I will accept it.
All
Dave,
right.
do you have any feedback before we go into my half?
I'll let you go ahead, Elizabeth, because I think we'll have time. I'll do the what if at the end, so I can actually just include all my stuff when I talk about that.
Sounds good. So